Hello students, I hope that you're all doing fine. In this lecture, we're going to cover the topic of quasi-contracts. And in the next lecture, we would move on with breach of contract. So let's start. So at the very offset, I would like to discuss with you this question because of its general nature. So this question was asked in UP PCJ 2013, as you can see on the screen, and it said, what do you understand by quasi-contracts? Number 1. Explain the distinctive features of quasi-contract. Number 2. What is juridical basis of responsibility occurring during quasi-contract? Explain. So you see that this question has many parts which we are going to answer separately and thoroughly in the duration of this lecture. So to begin with, the first part, that is, what are quasi-contracts? So there are many situations in which law as well as justice requires that a certain person be required to conform to an obligation, although he has neither broken any contract nor committed any tort. For example, a person in whose home certain goods have been left by mistake is bound to restore them. Such obligations are generally described, for want of a better or more appropriate name, as quasi-contractual obligations. Now, starting with the very theory of unjust enrichment, we see that law as well as justice should try to prevent unjust enrichment, that is, enrichment of one person at the cost of another. And Lord Mansfield, in the case of Moses versus McFarlane, has explained the same. Here, Jacob issued 4 promissory notes to Moses, and Moses endorsed them to McFarlane, excluding by a written agreement his personal liability on the endorsement. Even so, McFarlane sued Moses on the endorsement and he was held liable despite the agreement. Moses was thus compelled to discharge a liability which he had excluded and therefore sued to recover back his money from McFarlane. He was allowed to do so. After stating that such money cannot be recovered where the person to whom it is given can retain it with a safe conscience, Lord Mansfield continued, but it lies for money paid by mistake or upon a consideration which happens to fail, or for money got through imposition or extortion or oppression, or for an undue advantage taken of the plaintiff's situation, contrary to laws made for the protection of persons under those circumstances. In one word, the gist of this kind of action is that the defendant, upon the circumstances of the case, is obliged by ties of natural justice and equity to refuse to refund the money. Now, a liability of this kind is hard to classify. Partly, it resembles liability under the law of tort inasmuch as it arises independently of any contract, and partly it resembles contract inasmuch as it was owed only to one party and not to persons generally. Thus, it can be accounted for either under an implied contract or under natural justice and equity for the prevention of unjust enrichment. So, Lord Mansfield has preferred the latter theory, that is, the theory of unjust enrichment. Now we're going to talk about another theory before we actually begin with the real application of this given set of sections. So, beginning with the decision of the House of Lords in Sinclair versus Brougham, it became fashionable to discard Lord Mansfield's formulation and to rely upon an implied in-fact contract. A building society undertook banking business which was outside its objects and therefore ultra vires. And in this case, the society came to be wound up. After paying off all the outside creditors, a mixed sum of money was left, which represented partly the shareholders' money and partly that of the ultra vires depositors, but was not sufficient to pay both of them. The depositors tried to get priority by resorting to the quasi-contractual action for recovery of money had and received for the depositors' benefits, for otherwise the shareholders would be unjustly enriched. So here the House of Lords allowed ratable distribution of the mixed fund among the claimants, but did not allow any remedy under quasi-contract. Lord Haldane maintained that common law knows personal actions of only 2 classes, namely those founded on contract and those founded on tort. When it speaks of action arising quasi ex contractu, it refers only to a class of action in theory which is imputed to the defendant by a fiction of law. Now, we see that there has been a restoration of theory of unjust enrichment. And we see that the identification of quasi-contracts with implied contracts restricted the scope of relief which would have been possible without any such hindrance under the principle of natural justice and equity. The suffocation was felt by House of Lords itself in the case of Fibrosa Spolka Akejuna versus Fairbairn Lawson Com Babel Limited. So here a sum of money was paid in advance under a contract for the supply of a machine or for the supply of machinery, and the performance was obstructed by the outbreak of war. Their lordships allowed the advance to be recovered back as having been paid for a consideration which had wholly failed. Lord Wright lent support to Lord Mansfield's theory of unjust enrichment, and he observed, "It is clear that any civilized system of law is bound to provide remedies for cases of what has been called unjust enrichment or unjust benefit. That is, to prevent a man from retaining the money of or some benefit derived from another which it is against conscience that he should keep. Such remedies in English law are generally different from remedies in contract or tort, and are now recognized to fall within the third category of the common law, which has been called quasi-contract or restitution." Further, referring to the ratio decidendi of the decision of the House of Lords in Sinclair versus Brougham, Lord Wright pointed out that the case turned upon the principle that it was against public policy to allow the recovery of an ultra-vires deposit, whether the claim be based upon contract or quasi-contract. The observations of their lordships relating to the foundation of quasi-contract were merely obiter dicta. Indeed, the House adopted the pari passu distribution of the available assets as a technique to prevent the unjust enrichment of the shareholders at the cost of the depositors. Now, since we're discussing this idea of unjust enrichment, I would like to share with you this question that was asked in UPPCSJ 2006. It said the judicial basis of quasi-contractual obligation can be explained through. So, I'm sure you must have gotten it by now since we have discussed it many times. It is unjust enrichment. Now, enough with the theory. Now we're going to begin with the actual provisions which are mentioned in the Indian Contract Act in relations to quasi-contracts. So, Chapter 5, as you all know, of the Indian Contract Act deals with such situations under the heading of certain relations resembling those created by contract. The chapter avoids the words quasi-contract, and in view of the clear statutory authorization, the courts in India are not hindered in allowing relief under the different sections of Act by the theoretical considerations concerning quasi-contract. But English cases do provide valuable guidance not only as a scope of relief but also as the way the provisions should be interpreted to keep them in tune with the changing notions of justice. So Section 68 to Section 62 provide for 5 kinds of quasi-contractual obligation. And before we begin with this, I would like to share with you another question that has been asked in UPPCSJ examination. It said, how does a contract differ from quasi-contract? Enumerate the different kinds of quasi-contracts provided in Indian Contract Act of 1872. Now, in order to answer this question aptly, all that you need to do is follow the rest of this discussion that we are going to follow. So, starting with the very specifics, that is the first ground, that is Section 68 itself. Supply of necessaries. So, as under 68, where necessaries are supplied to a person who is incompetent to contract or to someone whom he is legally bound to support, the supplier is entitled to recover the price from the property of the incompetent person. Section 68 says, claim for necessaries supplied to person incapable of contracting or on his account. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries suited to his condition in life, the person who has furnished such supplies is entitled to be reimbursed from the property of such incapable person. So it has 2 illustrations where A supplies B, a lunatic, with necessaries suitable to his condition in life. A is entitled to be reimbursed from B's property. A supplies the wife and children of B, a lunatic, with necessaries suitable to their condition in life. A is entitled to be reimbursed from B's property. Now, since we have already covered this section, I'm pretty sure that you wouldn't have difficulty in solving questions coming from the same. Now, the second area is Section 69, that is payment by interested person. Section says, reimbursement of person paying money due by another in payment of which he is interested. A person who is interested in the payment of money which another is bound by law to pay and who therefore pays it is entitled to be reimbursed by the other. It has an illustration which says B holds land in Bengal on a lease granted by A, the zamindar. The revenue payable by A to the government being in arrear, his land is advertised for sale by the government. Under the revenue law, the consequence of such sale will be the annulment of B's lease. B, to prevent the sale and consequent annulment of his own lease, pays to the government the sum due from A. A is bound to make good to B the amount so paid. Now, we have discussed this section, but what are the conditions of liability? So, the very first thing is that payer must be interested in making payment. So, firstly, as held by the Allahabad High Court in Munni Bibi versus Trilokinath, the plaintiff should be interested in making the payment. The interest which the plaintiff seeks to protect must, of course, be legally recognizable. And his honest belief on this note that he has an interest to protect is enough. Now, secondly, payer should not be bound to pay. It is necessary that the plaintiff himself should not be bound to pay. He should only be interested in making the payment in order to protect his own interest. As held in Venkata Simhadiri Jagpati Raju versus Sri Lakshmi Rupa Dugaraju, where a person is jointly liable with others to pay, a payment by him of the other's share would not give him a right of recovery under this section. Now, thirdly, defendant should be under legal compulsion to pay. The defendant should have been bound by law to pay the money. The words bound by law have been held after some hesitation to mean bound by law or by contract. And as held in Rasappa Pillai versus Mitta Zamindar Duraisemi Rediyar, it is not necessary that the liability should be only statutory. It is enough that the defendant at the suit of any person might be compelled to pay. And explaining the purport of the phrase in Govindram Gordhandas Seksaria versus State of Gondal, where a Maharaja, having sold certain mills without paying overdue municipal taxes, was sued by the buyer who had to pay to save the property from being sold. Lord Ratcliffe said, the Maharaja was bound to pay this money in the sense that he made a legally enforceable contract with Seksaria to pay it. Unless the words bound by law to pay, where they occur in the section, exclude those obligations of law which arise inter parties, whether by contract or by tort, and embrace no more than those public duties which are imposed by statute or general law, the Maharaja was a person from whom reimbursement could be claimed under the section. But the lordships think that the words extend to any obligation which is an effective bond in law. Certainly, the common law of England afforded a right of indemnity to one who had paid under compulsion of law against the true obliger without limiting the circumstances in which the latter's liability had arisen. Certainly, too, there is authority in the courts of India for the proposition that bound by law covers obligations of contract or tort. Now, lastly, payment should be by one to another. That is, the plaintiff should have made the payment to another person and not to himself. Thus, in the case of Secretary of State for India versus Fernandez, where a certain government was the tenant of a land and paid to itself out of the rent due to the landlord the arrears of land revenue due to itself, the government could not recover from the landlord. It was a transfer of money from one head to another within the government and not payment to another. And though it was done to save the land from being sold in execution, it did not come within the principle of this section. Now the third section that comes under the 5 sections of quasi-contract is that of liability to pay for non-gratuitous acts. So section 70 creates liability to pay for the benefits of an act which the doer did not intend to do gratuitously. It says, obligation of person enjoying benefit of non-gratuitous act, where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. It has 2 illustrations where A tradesman leaves goods at B's house by mistake, B treats the good as his own, he is bound to pay A for them. Illustration B. A saves B's property from fire, A is not entitled to compensation from B if the circumstances show that he intended to act gratuitously. Now, conditions of liability under this section. They have been stated by Justice Gajendra Gadkar in the case of State of West Bengal versus B.K. Mondal and Sons. The condition on which the liability under this section arises can be called three primarily. The first one is that a person should lawfully do something for another person or deliver something to him. Number two, in doing the said thing or delivering the said thing, he must not intend to act gratuitously. And number three, the other person for whom something is done or to whom something is delivered must enjoy the benefit thereof. So, starting with not intending to do so gratuitously, thus one of the purposes of the section is to assure payment to a person who has done something for another voluntarily and yet with the thought of being paid. He should have contemplated being paid from the very beginning. And thus, in the case of Municipal Council versus MPSRTC, a municipal council which constructed and maintained a bus stand was allowed to recover some charges from bus operators who used to stand, though there was no agreement to that effect. Now, secondly, this section would not encourage officious interference in affairs of others. So, the person for whom the act is done is not bound to pay unless he had the choice to reject the services. As held in Haji Adam Seth Dharmasthapanam versus Hamid, if a person delivers something to another, it would be open to the latter to refuse to accept the thing and to return it. In that case, Section 70 would not come into operation. Similarly, if a person does something for another, it would be open to the latter not to accept what has been done by the former, and in that case again Section 70 would not apply. In other words, the person said to be liable under Section 70 always has the option not to accept the thing. It is only where he voluntarily accepts the thing or enjoys the work done that the liability under Section 70 arises. Chief Justice Jenkins, dealing with the scope of Section 70 in the case of Suchan Ghoshal versus Balram Mardana, said, the terms of Section 70 are unquestionably wide, but applied with discretion. They enable the courts to do substantial justice in cases where it would be difficult to impute to the persons concerned relations actually created by contract. It is, however, especially incumbent on final courts of fact to be guarded and circumspect in their conclusions and not to countenance acts or payments that are really officious. Now, students, I've been trying my level best to limit the content that I provide to you for different sections, because even I realized that as a student, or be it for any competitive exam, it must be really hard for you to go through all these cases and then revise them. So I try my level best to get to you the most important cases which are necessary to be known. There will always be more cases on any topic at all that you can know. There is no limit to knowledge. But then in order to clear this exam, I feel that it is important to limit the content that you study and keep on revising it. Now, thirdly, request for services creates implied promise to pay. Yes, it is necessary that services should have been rendered without any request. Reasonable compensation may, however, be recovered for services rendered at request. And this has been so held by the Supreme Court in State of West Bengal versus B.K. Mondal and Sons, whereby the facts were such that the plaintiff, on the request of an officer of the State of West Bengal, constructed a Kacha Road, guard room, office, kitchen, room for clerks and storage sheds for the use of the Civil Supplies Department of the government. The state accepted the works but tried to escape liability under the pretense that no contract had been concluded in accordance with the requirements of Section 175, Clause 3 of the Government of India Act 1935. Now this is the Article 299 of Constitution of India. So the contractor was thus forced to try his luck with the state under Section 70. And it proved to be better than that of the state, but at the cost of fighting up to the Supreme Court for a sum of Rs 19,325. So, in this case, Chief Justice Gajendra Gadkar examined the conditions of liability under the section and found that they were all satisfied by the facts and therefore held the state liable. There was no doubt he felt that the state, even after having requested for the works, had the right to reject. It could have been called upon the contractor to demolish the storage sheds and take away the material used. But if the state accepted the storage sheds and used them and enjoyed their benefit, then different considerations come into play and Section 70 has been and was invoked. Now, dealing with the term lawfully does, as mentioned in the section. So, services should have been rendered lawfully. And commenting upon this in state of West Bengal and B.K. Mondals and Son, as you must realize by now, this is a very important case law. The Supreme Court has said that the word lawfully is not a surplusage and must be treated as an integral part of Section 70. And even if it is taken to refer to an object of consideration which is forbidden by Section 23 of the Act, it cannot be taken to mean as requiring the state to pay under Section 70 for the services which it has enjoyed or something forbidden by Section 175. Fourthly, tackling the term lawfully does, as mentioned in the section. So services should be rendered lawfully. And commenting upon this in the case of State of West Bengal versus B.K. Mondal and Sons, the Supreme Court, and you must realize that by now that this is a very important case law. The Supreme Court has said that the word lawfully is not a surplusage and must be treated as an integral part of Section 70. And even if it is taken to refer to an object of consideration which is forbidden by Section 23 of the Contract Act, it cannot be taken to mean as requiring the state to pay under Section 70 for the services which it has enjoyed. Fifthly, in relation to non-gratuitous acts, the person rendering services should not have intended to act gratuitously. The decision of the Madras High Court in the case of Damodara Mudalayar versus Secretary of State for India is the leading authority. Here, a number of villages were drawing irrigation waters from a tank. Some of the villages were under direct state tenancy, others under zamindars. The government carried out repairs to tank for its preservation. The zamindars also enjoyed the benefits of the repairs. They were accordingly held liable to make proportional contribution towards the expenses of repair, and the case shows that even where the party making payment for rendering services is personally interested in the matter, he can recover proportional contribution from those who have enjoyed the benefit of his services. And lastly, in relation to enjoys the benefit as mentioned in the section, the defendant must have derived a direct benefit from the payment of services. This is the idea here. In the case of Governor General in Council versus Madura Municipality, where the works done by a railway company developed the adjoining lands and consequently the municipality received more taxes, this was held to be not a sufficient benefit to enable the railway company to recover compensation from the municipality. Now, talking about Section 71, which mentions the idea of finder of goods. It says, responsibility of finder of goods. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as a bailee. Thus, in respect of duties and liabilities, a finder is treated at a par with bailee. The finder's position, therefore, has been considered along with bailment. The Supreme Court has ruled in Union of India versus Amar Singh that the statutory fiction by which a contract of bailment is inferred between a finder of goods and the real owner should not be enlarged by analogy or otherwise, and therefore a railway authority which took into its custody wagons containing the plaintiff's goods and which were left across the border in Pakistan became the contractual bailees of goods, and it was not necessary to regard them as finders within the meaning of Section 70. Now lastly, the fifth and the last idea that this given set of sections comes up with is that of mistake or coercion. Section 72 says, liability of person to whom money is paid or thing delivered by mistake or under coercion. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. It has two illustrations. Number 1, A and B jointly owe 100 rupees to C. A alone pays the amount to C, and B, not knowing this fact, pays 100 rupees over again to C. C is bound to repay the amount to B. Illustration B. a railway company refuses to deliver up certain goods to the consignee except upon the payment of an illegal charge per carriage. The consignee pays the sum charged in order to obtain the goods. He is entitled to recover so much of the charge as is illegally excessive. So, talking about mistake of fact or of law, this given controversy between High Court decisions as to whether money paid under mistake of law could be recovered was set at rest by the Privy Council in the landmark case of Shiba Prasad Singh versus Maharaja Srish Chandra Nandi. So, payment by mistake, in this case it was said that payment by mistake in section 72 must refer to a payment which was not legally due and which could not have been enforced. The mistake is on thinking that the money was due when in fact it was not due. That the money paid was due when in fact it was not due. There is nothing inconsistent in enacting, on the other hand, that if parties enter into a contract under mistaken law, that contract must stand and is enforceable, but on the other hand, that if one party acting under mistake of law pays to another party money which is not due by contract or otherwise, that money must be repaid. Moreover, if the argument based on inconsistency with section 21 were valid, a similar argument based on inconsistency with section 22 would be valid too and would lead to the conclusion that section 72 does not even apply to mistake of fact. It may be well to add that their lordship's judgment does not imply that every sum paid under mistake is recoverable, no matter what the circumstances may be. There may, in a particular case, be circumstances which disentitle a plaintiff by estoppel or otherwise. So, a question was asked in UPPCSG examination of 1999. It said, payment received by mistake must be refunded. Discuss with reference to decided cases. So, we could easily answer this question by mentioning section 72, its two illustrations, and the landmark judgment of Shiva Prasad Singh versus Maharaja Srish Chandra Nandi, where the Privy Council, as you must realize, has stated that section 72 makes no distinction between mistake of fact and mistake of law, and that section 72 must be read together with the rest of the Act, in particular section 21 and section 22, which also deal with mistake. Now, talking about the cases related to limitation and laches. Recovery proceedings generally are instituted by way of writ petition. So, there is no period of limitation applicable to writs. The only requirement is that there should be unreasonable delay amounting to laches. And it has been held on this note in the case of Christine Hoden versus N.D. Gadak that the period of limitation would not begin to run until the applicant has discovered the mistake or could have discovered it with reasonable diligence. The claim was laid within a month of the mistake of law becoming known. It was held that the claim could not be defeated on the ground of limitation. Now, there is a case of National Pari Mutual Association Limited versus R, which highlights the idea of discovery of mistake after long period. So, in this case, an accounting error was committed by the corporation in recovery of loan and interest. The mistake was realized after more than a decade, and an attempt was then made to recover the amount that remained unrecovered and interest on it. So the court said that interest was not to be allowed. It would be unjust enrichment at the cost of the other and also penalty for the fault of the creditor. Now we have an authority where acceptance of less sum under court orders was subjected. So in ONGC versus Association of Natural Gas Consuming Industries, in a contract for supply of gas, the seller's attempt to increase prices was challenged. The court directed by an interim order that the supply should be continued at original prices. The proposed enhancement was finally found to be valid. It was held that the consumers were liable to pay the differences in prices since the first notice of escalation and also interest on delayed payments. The court applied the principles of deemed renewal and restitutions here, and the terms of the original contract had acquired. Now, in relation to coercion, the word coercion as used in this section is used in its general sense and not as defined in section 15. Thus, money paid under pressure of circumstances such as prevention of the execution of a decree on a property in which the party paying is interested may be recovered even though coercion as defined in section 15 is not established. Now lastly, I would like to discuss with you the idea of quasi contracts in English law, just so that if a question is being asked on this topic, on this subtopic, then you are perfectly able to answer the same. So we see the idea of payments to the defendant's use. Two principles seem to govern this kind of quasi-contractual liability. One of them is that payment should have been made under pressure and not voluntarily, and the other is that the defendant should have been bound to pay and has been relieved of his liability by the payment made by the plaintiff. So, an expenditure or payment made purely voluntarily will not do, as seen in the case of Falk versus Scottish Imperial Insurance Co., where a person pays premiums due upon the policy of another without his request and without any compulsion, he cannot recover. Now, in relation to voluntary payments, and under that, in relation to payments made under mistake of fact. Payments made under mistake of fact, we notice, can be recovered provided that the party paying would have been liable to pay if the mistake in fact were true. So, in relation to that, in the case of Kelly versus Solary, where money was paid under a life insurance policy which to the knowledge of the company had lapsed, but the fact of lapse having been forgotten at the moment, the company was held entitled to recover back the money. Now, in relation to payments made under an ineffective contract, so three kinds of situations are generally considered under this head, namely total failure of consideration, money paid under a void contract, and money paid under an illegal contract. Now we know that the effects of void and illegal contracts have already been considered, and in relation to the total failure of consideration, where one of the parties to a contract has paid money in the performance of his part, but the other party fails to do his part, then the former has an option, namely either to sue the other for the breach of contract or to treat the contract as at an end and recover back his money under quasi-contract. Quasi-contractual remedy arises when there has been a total failure of consideration as opposed to partial. For example, in Wilkinson versus Lloyd, where a shareholder of a company transferred his shares to the plaintiff for which the price was paid, but the company, on account of certain conduct on the part of the transferor, himself refused to register the transfer of his shares, this was held to be a total failure of consideration, enabling the plaintiff to recover back his price. In relation to that, payments are made under compulsion. In the case of Maskell versus Horner, we see where the owner of a market realized tolls from a shopkeeper by seizing his goods, and it being subsequently held that he had no such authority, the shopkeeper was allowed to reclaim the toll money. But, as seen in Tyford versus Manchester Corporation, where any such fee or toll is paid without improper pressure or compulsion, there would be no right of recovery. Now lastly in this lecture, talking about the idea of quantum merit in reference to this section, where a party has in the performance of his contract done some work or rendered some service and the further performance has been made useless by the other party, he may recover reasonable compensation for the work or service. So, Planch versus Colburn makes a pretty good example in this context. The plaintiff was the author of several dramatic entertainments. He was engaged by the defendants, who were the publishers of a work called the Juvenile Library, to write for that work an article to illustrate the history of armor and costumes from the earliest times, for which he was to be paid 100 guineas. The plaintiff made various drawings and prepared a considerable portion of manuscript when the defendants discontinued the Juvenile Library. Then the plaintiff claimed a sum of 50 guineas for the part which he had prepared and the trouble he had taken in the business, and he was held entitled to it. That sums up this lecture, students. In the next lecture, we're going to continue with breach of contract. Thank you. Till we see each other again.